We start with iTeammate, a stunning change of events. Kegan Kline now says he may want to change his guilty plea in his child porn case.
That stunning request came just minutes before he was to learn his prison sentence. iTeammate's senior investigative reporter Richard Essex has been following this case from the start and was in the courtroom today.
When Kline entered his guilty plea, there was no guarantee for the prosecution on how much time he would serve in prison. And as it turns out, there's no guarantee he would stick with the plea agreement. Kegan Kline left the courtroom surrounded by sheriff's deputies and a legal case spinning with uncertainty. Kline had agreed that today he would learn his prison sentence on 25 child porn-related charges. Instead, he suggested that he may withdraw his guilty plea. The team of lawyers from the prosecutor's office vehemently opposed in court any further delays and exited the courtroom in a fury.
No comment today, guys. Thank you.
The prosecutor in Miami County would like to see Kline in prison for as long as possible by serving consecutive sentences, arguing in court filings last week that his crimes did not constitute a single episode of criminal conduct, but instead constituted several crimes of violence. In March, when Kline entered his guilty plea, he told the judge he was clear-headed and understood the consequences of his guilty plea. Kline now claims he didn't have time to review all the evidence and may withdraw his guilty plea.
And because of that, Kegan wants to have time to review it and maybe even possibly withdraw his guilty plea. And of course, the prosecution very strongly took issue with that characterization.
In court this morning, Kline's attorney seemed just as surprised by his client's statements. He said that he was prepared to move forward with the sentencing hearing today. The hearing was scheduled to begin at 9 this morning. It became clear by 9:15, judging by the scurried movements of lawyers, police, and other courtroom staff, that the hearing would not go as planned. The prosecution team told the judge any delays were unacceptable.
They characterized this as a delaying tactic, indicating that they believe Kegan just wants to draw this out as long as possible.
Neither Kline's attorney or the prosecution would talk about what happened in court today. It is unclear if Kline does attempt to withdraw his guilty plea, whether the judge will accept it. In 1 week from today, all the parties will be back in the courtroom, and we'll get some answers to some of these questions. In Miami County, Richard Essex, Wish TV, iTeammate.
Let's welcome in Wish TV expert and criminal defense attorney Mario Massiomani. Mario, Kegan Kline may try to withdraw his guilty plea. Just how common is this? What is the precedent?
It's not very common. Honestly, the courts look at and give a lot of latitude to the trial court judge in determining if a defendant is allowed to withdraw their plea. A lot of times the defendant or the defense counsel is going to have to articulate to the judge why this has to be done. Specifically in this case, looking at the guilty plea that was conducted, the trial court went into detail and asked specific questions, asking Mr. Kline if he understood the specific terms and conditions of the plea that he was pleading guilty to. So I think it's going to be very challenging for him to be able to get out of this plea because the judge was so thorough.
I want to talk about what has to happen then to withdraw a guilty plea, mentioning what you already have. What are the things the judge must consider? There seem to be many.
So one of the main things I think in this case is the defendant had informed the judge at the guilty plea hearing that he has some mental issues, mental diseases, diagnosed mental diseases. And so I think that if his defense attorney were to make the argument to withdraw this guilty plea, I think the defense attorney would need to emphasize the fact that the mental conditions might have impacted his ability to understand what was going on in that court hearing, and that he does not truly know or understand what he was pleading guilty to. Another factor that could come into effect is that the defendant might try to even throw his attorney under the bus. In this sense, say that there were things that we had discussed that were not part of the plea or that were not explained to me prior to me admitting and pleading guilty in that hearing.
Well, let's say the plea is withdrawn. Kegan Kline is on record under oath saying he did each of these crimes. Can that be used against him at trial?
It could potentially be used against him at trial. And as a defense attorney, what I would try to articulate if the prosecutor tries to bring this up is that and it really depends on what argument I made during the withdrawal of the guilty plea, I could try to argue or articulate that my client has these mental issues, has these diagnosed mental history that would make it impossible for him to truly admit his guilt. And that's why, to a jury, they should not use whatever statements he made during the factual basis or whatever he admitted to, that because of the mental diseases that he has, that he didn't truly understand what he was doing or what he was admitting to. Now, in that factual basis that I saw the judge conduct, it was pretty thorough in what was asked of him, what he was asked to admit to. So it's going to be very difficult for the defense attorney to be able to make any sort of valid arguments as to why this defendant, Mr. Kline, did not admit to the specific elements of the crimes that he admitted to in the guilty plea.
A lot to still determine here. Mario Massiomane, thank you for weighing in.
Thank you.